Well, welcome everyone to our little podcast on Google v. Oracle. Opinions come out from the Supreme Court, and so we're going to talk about it. I'm Guha Krishnamurthy. I'm an assistant professor at South Texas College of Law, and in the fall, I'll be an associate professor at University of Oklahoma College of Law.
Bravo. That's just a congratulations to you, man.
Thanks a lot. Thanks a lot. And I'm joined by Travis Wimberly and Abraham Howland, and I'll let them introduce themselves.
Yeah, you want to go first?
Yeah, you go first. All right, cool. Yeah, my name's Abraham Howland. I'm a software developer. I've been a software developer for about 4.5 years, do some consulting work. And yeah, I'm here to answer, give a little opinion from a software developer's point of view about the opinion, but I'll leave all the legal stuff to these two.
Oh, you are a lawyer. You did go to Boston University.
Yeah, it's been a long time.
I'm Travis Wimberly. I am a partner at a law firm in Austin called Perky Barber. We are a trademark and copyright law boutique firm. So copyright, which is of course the subject of this opinion, is a pretty big part of what we do and what I do personally in my practice.
Awesome. So Travis, do you want to take away and just give us a discussion of the case?
Yeah, so it's a really thick procedural history and factual history to this case. So I'll just try to hit the high points because I could talk about it for half an hour if I try to go in all the detail. So basically, Oracle, which was previously Sun Microsystems, owns the Java programming language and the Java API. And the API is, for lack of a better term, a programming interface that developers can use to build new programs, build new software. So Google, in building Android, the Android operating system, took some parts of the Java API and copied them. And it didn't copy all of the Java API. In fact, it didn't even copy most of the Java API, but it copied these certain parts of it called the declaring code, which I'm sure Abe will help us sort of understand the difference between declaring code and implementing code and all that stuff. But just for purposes of this brief background, what's important to know is that Google, in building the Android system, copied a small percentage of the Java API. And the reason they did that is because they wanted people programming for Android to be able to call and use familiar Java functions like they had already learned from years and years and years of programming in Java for other platforms. So it's basically a convenience thing. You want to build programmers into your ecosystem. It's good to give them a familiar way to call functions that they've been used to using in other contexts. So Google did this as part of developing Android. Other than the little slice of this they copied, they wrote all the code themselves. It was about 100 Google engineers who wrote all the rest of the Android code. So they build this system out, they build Android. Obviously, Android has become wildly successful since then. And at some point, Oracle buys Sun, and pretty quickly after that files this lawsuit. Sun, for whatever reason, was not so interested in suing Google, but Oracle was rather interested in suing Google. And initially, it was both a copyright lawsuit and a patent lawsuit. Oracle had claims on both. And we won't really talk about the patent stuff because, long story short, the patent stuff went to a jury, and the jury said, no, there's no patent infringement here, blah, 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 out of the case. So we're left with some copyright issues around the software code in the Java API. Software code as a general proposition is copyrightable. I'm speaking at a very high level there. There's obviously some very specific issues about whether this particular software code is copyrightable. We're going to get to that. But as a very general proposition, it's been established for many decades that you can copyright certain software code. And in fact, it's kind of funny, software code receives the same type of copyright as like books and movie scripts and any other form of literary work. That's actually the category it goes under. Most people don't think of code as literary works, but that's really the only applicable copyright category for it. So that's where it goes. So anyway, patent stuff out of the case, we're left with copyright. Goes to a jury trial on copyright infringement for these lines of code that Google copied, and admittedly copied, by the way. There was no dispute. Google said, yes, for the declaring code, we copied it. and here's why we did it. So it was not disputed that they did that. Goes to a jury trial, and actually the judge says, well, wait a minute, this type of code is not copyrightable. So it does, what the jury thinks doesn't matter. I'm saying you can't copyright this type of code. That goes up to the Federal Circuit. They reverse that. They say, no, we think this type of code is copyrightable. Goes back down, another jury trial. This time jury says, okay, this is copyrightable. We've been told that by the Federal Circuit, but we think this is fair use by Google. Fair use is a defense to copyright infringement. So jury says fair use. Goes back up to the Federal Circuit again. Federal Circuit says, we don't think this is fair use. Overturns the jury. So 2 times in this case, a decision by the district court got overturned by the Federal Circuit, which at some point, you and I have talked about this before, as a litigator, man, it's got to be frustrating to keep going to trial on a case. I mean, when you win the appeal, it feels great, but it's also like, why do we spend so much time going to trial if 3 appellate judges are just going to constantly be like, nah, we don't think so, whatever we think. So Federal Circuit says, we don't think this is fair use. At that point, it goes up to the Supreme Court, and that's the decision that we're talking about today. There were really 2 issues before the Supreme Court. The first one is whether this type of declaring code is copyrightable at all. The second issue is whether Google's particular copying of this code was a fair use or not. And I think we'll talk about this more, but the Supreme Court actually did not end up deciding that first question. They just skipped it and went straight to the fair use question. So that's where we're at. That's the background for the case. I think I'll probably stop there, if that's okay. Guha, is there anything you think I left out that's critical?
No, not at all. And one thing I'll just note is that this case had so many big players involved. So you obviously have Google and Oracle, but at the in the amicus brief, collection, we have so many big companies, small companies, and a lot of really important scholars. David Nimmer on copyright, and Arthur Miller, who was involved in the federal practice and procedure.
Federal practice and procedure.
Yeah. So we just have like a who's who involved in this case. Yes. And one thing I think that you mentioned in the procedural history that's of interest is the fact that the Federal Circuit, right, had such a role to play in this case. And you can say, well, why did this case go in front of the Federal Circuit at all? Yeah. It's dealing with copyright, so why was it there? Well, it's interesting because the Federal Circuit has exclusive jurisdiction over matters of patent. And the patent issues, as Travis mentioned, were out of the case, right? But nevertheless, because the claims were brought in the initial case, the Federal Circuit still had jurisdiction.
That's right. And it's a little bit, you could dive into that a little bit, but the short answer is what you basically just said. Because there were patent claims in the case at one point, which invoked the Federal Circuit's exclusive appellate jurisdiction, no other appellate court is allowed to hear patent claims besides the Federal Circuit. Basically, long story short, it stays on the Federal Circuit path for the successive appeals, even though the patent claims are out of the case. And it's a little bit wonky. I think there are some details to that probably are not that important to discuss, but I think the takeaway is if you've got patent claims in the case early on with some other stuff, even if the patent claims go away, and in most situations, you're going to end up still exclusively in the Federal Circuit on appeal.
Do you think that was desired by one of the parties here?
You know what? If I was speculating, I'll speculate a little bit. If I were Oracle, I would have wanted that, especially after the jury verdict on fair use came in, because I think the Federal Circuit, more than any other circuit, because they're IP specialist judges on that court, they are very willing to say, we don't care what a jury thought. What we think is more important, we overturn that jury verdict. So Google probably would have preferred it go somewhere else. They probably would have preferred it go, to the Ninth Circuit or whatever the regional circuit would have been. But I bet Oracle, once they got hit with that jury verdict of fair use, they were like, yeah, Federal Circuit, let's do this.
And I'll say that Nimmer, he filed an amicus. David Nimmer, the very famous IP scholar, filed an amicus, basically complaining that the Federal Circuit shouldn't have this jurisdiction because all these software claims are going to come with patent claims as well. And so it's basically giving the Federal Circuit kind of like a de facto exclusive jurisdiction over software IP issues. And so, and I'll say that my judge, the judge I clerked for, Diane Wood, has written really eloquently about, well, the Federal Circuit really shouldn't have jurisdiction over all these issues, as an exclusive jurisdiction over all these issues, and the regional circuits are smart and fully capable of handling them. So I'll just throw that out there.
Well, a brief aside on that, which I've always found interesting, is lawyers and judges, I think, who aren't IP specialists sometimes like volunteer this aversion to IP. And sometimes it's almost like they're questioning their own ability to grapple with IP. And I think a lot of people really undersell themselves on that, both lawyers and judges. Like, Guha, you're not an IP guy, like necessarily specifically,
no,
but you're a very smart guy and a very smart lawyer. And every time I've talked to you about IP stuff, you get it. Now, I'm not saying you profess to be an expert in every little IP issue. But one thing I've noticed is that judges I've talked to on other, the non-federal circuits, basically, or even some trial judges, they're always kind of like, oh, IP, I don't know, this seems pretty complicated. And I'm, yeah, it's complicated, but lots of cases are complicated, that's part of the job. So I don't know who I'm really talking to when I say this, but like just out to the legal world, don't undersell your ability to grapple with an IP case. Like, you can do it, you're smart.
That's right. I mean, you as well, like, it's not like you're like an expert IP litigator, but, like, you didn't have like a sort of technical undergrad or anything like that. And it's like, you can just be good at it. It's the law. So.
Right. That's right. I came from a radio, television, film background. So you do not need to be an engineer to understand IP issues. That's for sure.
Yeah, that's right. So do you want to lead us off with just like what the Supreme Court decided here?
Yeah, I do. And then I think it'd be great to hear some from you and Abe, since I've been talking for a while. So the decision was actually, the bottom line of it is actually pretty simple. The Supreme Court, as I said before, skipped the copyrightability issue 1, which is whether this declaring code can be copyrighted at all. And they said, basically, we assume for purposes of argument that it can, but we're not deciding that. And they have some reasons. They said they weren't deciding it. I have some theories or opinions about why they skipped that. The most simplest explanation is always like, why decide the more difficult issue that's going to have broader ramifications if you can do something a little bit simpler? And I'm not saying the fair use thing is all that simple, but it will, the fair use decision will create less of a ripple effect than I think the decision on copyrightability of this type of software code would have. So anyway, they skipped that issue. They said, assume it's copyrightable. And then they went to fair use and they disagreed, the Supreme Court did, with the Federal Circuit, which had said this was not fair use. And the Supreme Court said, we think this is fair use. So basically you've got the jury and the Supreme Court agreeing that it's fair use. And the only ones who didn't were the Federal Circuit. And we can go into that in a little more detail, but that's the bottom line of the opinion. It was a 6-2 decision. The reason it wasn't all 9 is because Justice Barrett was recused from the case. And I actually don't know the reasons she was recused. Maybe she's a major stockholder in Google or something. I don't know. But anyway, she was recused, did not participate in the case. So you got a 6-2 opinion with Breyer writing for the majority of 6. And then you've got Justice Thomas and Alito as the dissenting 2. And I'm sure we'll talk about all that more. But basically, the 6 of them felt this was fair use, and Thomas and Alito felt it was not. And Thomas also, in his dissent, pretty strongly criticized the majority for skipping that first issue. He basically came right out and said, you really can't decide fair use without looking at the copyrightability question first, which I actually don't think he's right about that, but there is an undercurrent to that, which I understand, which he's basically saying, maybe there would have been things informing your fair use analysis if you had also analyzed this first issue. I think that's fair to say. I don't think it's required. I think you can absolutely decide fair use without deciding a copyrightability issue, but it may be that the analysis of the first issue might have helped in some way. I think that's fair. So anyway, I've been talking for a while. Why don't you guys, love to hear from Abe about some things.
Yeah, absolutely. And I think one thing I would just say is like, we should start with kind of the factual background here and there are just a ton of like analogies about what this software is like and what copying is like. And I think Abe, if you could give us some enlightenment on those, that'd be great.
Yeah, sure. Yeah, I actually think so. What I saw when I was following this case is that there was a lot of interest in it from people on the software side of things, programmers, and what people really wanted them to settle that first issue. They wanted to know, hey, can you copyright? Our APIs copyrightable? But by which I mean, so let's define some things. API stands for Application Programming Interface. The key concept here is the interface as opposed to implementation. So a good analogy, that's not a Harry Potter analogy or something, is I know how to drive a car, but I don't know how it works, right? I know how to interface with the vehicle. I can steer it, I can push the gas, I can push the brake, I can get in, turn the car on. That's about it. That's about all I have to know to drive a car, okay? I don't know how the car actually works. Same thing with any complex system. It's composed of a bunch of, you can decompose it into a bunch of components, but sort of where those components meet, there's going to be some sort of interface. Component A doesn't have to know about how component B does what it does. It just has to know how to interact with it. So same thing's true with your computer. It's all components and interfaces all the way down. So you can't imagine how. So I guess what I'm trying to say is that this notion of interfaces is extremely pervasive, and this is an extremely general question of, the code that that defines an interface. That's code that someone who's sort of providing that interface is exposing, and then it's code that's the client that's going to use that interface is interacting with. So this question of, our API is copyrightable, is this interface code copyrightable, is an enormous question. I'm not surprised that we didn't get a holding on that, because as you say, it would have this huge ripple effect. But I'm wondering if they just sort of kick the can here in a lot of ways. Like, are we going to see another case next year where the same issue is raised yet again? Yeah, analogies that are bad. Let's start there. If you say that, here's the difference. It's like a Harry Potter book, and the chapter titles are the interface, and then the implementation is the actual pages of the book, the actual text. That's not right, because that's not how I interface with the Harry Potter book. When I interface with the Harry Potter book, I read the whole thing. That's how I interface with it. Okay. So the big difference between software and a book is that, at the end of the day, yes, I'm writing some source code, but I'm compiling it into something that assumes an execution sort of context. It assumes that there's going to be a processor that's going to sort of make this chug along, that there's going to be memory, that there's going to be input and output devices and all this sort of stuff. So yeah, I think a lot of these analogies sort of miss the mark, because they don't actually have anything to do with interfaces and implementations. And that's what this is all about. I do sort of want to curiously sort of like bring up an example that sort of has a role reversal here, right? So here Oracle's saying, you copied our code and you copied this API code, but of course, Oracle has been in a similar situation where Amazon released, this service called S3, where you could store. It was basically a storage and retrieval service, and then Oracle released a product that was S3 API compatible, right? Where they said, "Hey, you've been using S3. That's cool. We'll expose a similar product that has the exact same API." So it's not like, if it had been held that APIs are copyrightable, that Oracle would have, won the day and not been affected at all. It would have had these massive ripple effects. There would be a huge storm of litigation from all sides. Yeah.
So that's great. Can I ask, just for like the more fundamental thing, because there's like a few things going on here, right? There's this API, there's implementing code, there's declaring code, and then there are method calls, and there are some funny diagrams that purport to explain what these things are. And I'm just wondering if either or both of you can, just sort of like lay out kind of what's going on.
I think Abe should definitely start there.
Yeah, no, I'll give a very simple example. So let's say I'm someone working on creating this Java software development kit. Okay, and I think that, look, when somebody writes a program in Java, they're going to want to know how to sort lists, okay, in ascending order or descending order or something like that. And I certainly don't want someone who's going to write an application in Java, everybody to have to reinvent the wheel again and again and again, right? So I will provide a software development kit that has a sort function, and they can pass in their list and maybe a comparison operator, and then I'll do the sorting for them. So I might write that function in Java. Java has the notion of, well, everything's basically a class with some methods on it. So method and function mean the same thing in this context. But I actually might just actually implement that sorting function. Okay, but every function has a name, and then it has some parameters like that you have to pass it as input, and it has a notion of what the type of thing that it will produce as output is. And so that's called a function signature, or you might call that declaring code or whatever. That's what they're referring to as declaring code. So just like sort takes a list and this operator, and it returns the list or something. And that's an interface, because the client doesn't have to know anything about how I implement sort at all. The person, and by the client I mean the person who's writing code that invokes sort, that calls the sort function. So now you can imagine that the Java SDK has like thousands of these things. Sort, here's how you manipulate graphics, here's how you write to a file, here's how you send data over a network, this sort of stuff. And you could, as Google did, re-implement all of that stuff, and they did do that. But if you want people to be able to take to do one of two things: either take existing programs that they've already written in Java and say, now I want them to run, on Android or whatever, or to just be able to still write the same old Java to the same old API that they used to, then you're going to have to implement an existing API, which is what Google was doing in this case. Yeah.
So I understand it. Using your sort, a function that sorts a list, Google rewrote the actual code that would do the sorting. Yes. Like the code that does the work, Google rewrote that. And in every instance, they rewrote that code. But what they copied was the code that tells you, this is how you call the function, these are the parameters you pass to it, right?
Exactly. Right.
So can I maybe beat this to a dead horse and use your car example again? It seemed to me like Google built a car, right? But then in terms of like how the steering wheel and gearbox and all of that layout looked, and if you think of it like an F1 car, that can be pretty complex. They just duplicated that. Is that like wrong, or is that okay?
Yeah. Well, it depends. It would be like, I think that's mainly right. I might tweak it to say they gave the car a steering wheel and mirrors, and they gave it, a gearbox and all this stuff. And it's like, well, that's what you expect, right? So I mean, well, here's the deal: is that just like this is, why this is so important generally is that, of course, when people develop groundbreaking like software products, like if you say that APIs are that you're never going to be able to mimic that API, then it will never happen that somebody creates a competitor to that matches that interface. Like, it's so expensive to get people to, basically what you can do is you can get people to swap out the services and the backends that they already use, right? But the only way that you can easily get them to do that is by sort of matching that interface in some way. So to use the S3 example, Oracle could say, I see you were storing your files with Amazon using their S3 service. You don't have to really amend your client code at all. You just have to point at a different URL. It'll still work, and you can use our service. That's incredibly important. And that's actually something that in the industry, when you're deciding what sort of tech stack are we going to build on top of, you're making sure that you're often making sure that you have an exit strategy. Because what you don't want is vendor lock-in. You don't want to say, hey, we're using this, and then, okay, well, what if the vendor doesn't support you after a while, or they go defunct or whatever? Oh crap, we're stuck. You know, it will be a gargantuan effort to use something else instead. No, you're always sort of looking for these places with API compatibility, and it produces a lot of efficiencies for the industry. Some would argue.
Can you, on that point, and I think this is really important to the fair use conclusion. We'll come back to that in a second. But a question for Abe is, when you're a software developer, what is the value to you as a developer of what Google did here? What Google did in copying this declaring code from the Java API? How does that benefit you as the individual developer? Because part of Google's theory in this case, I think, is we did this to make things easier and more beneficial for Android developers. So can you explain a little bit why that benefits the developers?
Yeah, so, okay, so imagine I'm deciding whether to write a program that will run on Android to begin with. So imagine I have a new idea for some application or some service or anything, right? Now, when I decide, like, okay, what language am I going to write this in? What tech stack am I going to assume? I'm thinking, where am I going to be able to run this code? How am I going to actually be able to deploy it? And it's super helpful if I say, oh, well, it's a Java program, so it can run over here, and it can run over here, and it can run over here. And yes, maybe I'll have to modify some things, but I won't have to like reinvent the whole program, right? Yeah. So this is an incredibly important decision. In fact, ironically, like it was, if you look at historically, like why Java is so prevalent, that was its promise, was you can write it once and run it anywhere. That's the promise of the JVM. The JVM is this Java virtual machine. You write Java, and it runs on this JVM. And the idea was, hey, the JVM could run anywhere. Now that hasn't exactly panned out, but that was basically the idea. So that's the idea, is that yeah, I don't know.
That makes sense. So I think a sub question to that, and I think the answer to this is yes, but you tell me. So, you know, when Android is new, like when it's first coming out, and obviously part of what Google wants to do is attract talented programmers to write applications for Android, right? I assume part of their sales pitch, and one of the reasons they did this, is these talented programmers, a lot of them have been coding in Java for years already, and they know a lot of Java. And Google wants to be able to say, hey, you can come program on the Android platform, and in doing that, you will be able to call certain Java methods that you've been using, that you've known for 10 years or whatever. Yeah. Is that part of the appeal here?
Yeah, exactly. Well, so if you think of it, if you just go back in time and you say, well, wait, what happened with the iPhone, right? And, you know, iOS and stuff. Now, if I wanted to write an application that would run on iOS, you know, a decade ago, I would have had to say, okay, I'm going to learn Objective-C, right? And I'm going to do it the Apple way. And at the end of the day, I'll have something that runs on the iPhone or the iPad or whatever. And so you could ask, since Android sort of came a little later, like, well, I think that Google didn't want that same risk, right? If they say, no, we're gonna, you know, we're not gonna get the benefits of people who have already written code in Java just being able to easily or relatively easily convert those applications to run on Android, then they run a huge risk. Because why does anybody, when they're deciding, I want to run something I want to write an application that's going to run on mobile, and they have to make a choice, do I write that in Objective-C or do I write that in Java? Why would, or not Java, but whatever sort of stack Android chose, like that would be a huge issue. So that was a huge win for them, and probably a way to competitively get where they wanted to be, I would think.
So I think that like the opinions are very subtle about this and they don't say enough about it, but I think we could do a little exploration about talking about Google's market strategy. How does Google make money on this Android thing? And how does Sun, or Sun Microsystems and Oracle, what was their market strategy? And maybe a little bit about why they couldn't come to an agreement. We might have to speculate a little bit, but why they couldn't come to an agreement on the license. And I don't know if either of you have ideas about this.
Well, so I know a little bit about this history, but I don't know a ton. What I do know is that, so Sun is known for some operating systems like Solaris. They're known for Java, and then of course Oracle acquires Java, but interestingly, and Sun had a lot of these. Sun had ZFS and some other very interesting piece of technology that Oracle acquired. When Oracle acquired some of this stuff, you actually had this schism of like, now we have an Oracle JDK, like an Oracle Java, and we have the open JDK, like an open Java, okay? And the same sort of thing happened with a few other pieces of technology. So I think that Oracle, Oracle really likes this model, and maybe I'm speaking out of turn here, but you could ask the question generally, how do I make money with software?
Yeah.
Okay. Yeah. Because that's changing over time. And one way traditionally was, I'm going to sell licenses for my software. And that model is still working for Oracle, right? And it probably will work for a company of its size. But for other companies that are not giants like Oracle, that's a very difficult model, especially as it becomes easier and easier to share things on the internet. I have no idea who's actually running my software. Even if I did, am I gonna, go after them, send the lawyers after them, or what's the deal, right? So you've seen a lot of companies move towards like, well, I will sell my software as a service, basically. And Google and Amazon have really leaned into this in terms of not only are they selling software as a service, but they're selling platforms for other businesses to sell software as a service. Right. They're selling their compute, hey, come, you've got an idea. Not only should you sell your software as a service, but you should do it on GCP or you should do it on AWS or whatever, right? Right. And they're getting a lot of benefit of this, just to take an example, let's say I've got a small company, I come up with a cool idea for some software, let's say like a database product, and it matures into a database that others want to use. Well, a company like Amazon has been known to say, hey, that's a cool database product you got over there. It'd be a shame if I were to sell that as a service, right? And so that's sort of their model. They're really leaning into into that sort of model. And quite frankly, it doesn't seem like they have use for the Oracle model of, well, we're gonna have maybe some very restrictive licensing terms and go after you if you break them. So I don't know. I mean, it really seemed like what Google was pushing for was like, no, an outcome where the outcome was like, hey, APIs aren't copyrightable. And I don't know if that's what they really wanted, but obviously that would be a huge, huge change. Yeah. But I also, it wasn't a holding, I don't think, that no APIs are clearly copyrightable, and that would be an equally huge thing, because it would mean like now, well, shoot, everybody uses APIs all over the place, and they're constantly trying to match others' APIs and re-implement things. So, right. What would that mean for the industry?
Right. Yeah, they have a comment in there. Breyer's majority opinion has a comment about why they skipped that issue, and he basically says, I'm paraphrasing, he basically says, with as fast as technology is moving and the economy is changing all the time, like we don't think it's wise to decide this issue here today. basically the ripple effects that we talked about would be too great. Which, Juha, you know firsthand, I know firsthand, appellate courts will skip the harder issue and decide on the easier one all the time. It's very well accepted practice. I don't even necessarily think there's anything wrong with it in a lot of cases. Abe brought up the point of, will this just come up again? The answer is absolutely yes. The funny thing is, of course, from the Supreme Court's perspective, they never have to decide it, because if it ever comes up and they don't want to, they can just not take the case, right?
That's right.
And they can just do that forever. However, it will come up again in the federal circuit. Maybe at some point it can come up again in a regional circuit, because there's not a patent claim forcing it to the federal circuit. And as you know, those courts have to decide the issues before them. They don't have discretionary review. Now, they can come up with ways to decide cases sometimes without deciding the big issue, but they won't be able to just say we decline the case entirely like the Supreme Court will. So it's kicking the can down the road in some way or another. We'll see if any court, whether at the circuit level or maybe one day at the Supreme Court level, ever has the, I'll say, the guts to actually tackle it head on. But who knows? I mean, it's such a thorny issue, and you're never going to make anybody happy, right? I mean, look at the amicus participation, Guha, that you talked about. It was about equal. We talked about the level of it, but one thing we didn't talk about is it was a pretty even split. It wasn't like all these amicus briefs for Oracle or all these amicus briefs for Google. It was roughly 50-50. And the amount of heavy hitters was roughly 50-50. I mean, obviously you can categorize people into certain camps based on what their background is, or the companies based on what they do. But when you look at it, like, it was about half of them were amicus briefs saying, absolutely, API should be copyrightable. What are you talking about? And the other half are being like, no way, man, like, you shouldn't do this. It would be terrible. And then some of them weighed in on fair use too, and said, well, if they are copyrightable, it should at least be fair use, because I want to be able to, do this. It's easier. It's interoperable, whatever. So I think that it is kicking the can down the road. We'll see. I mean, we'll see if it ever comes up in a context where it becomes very difficult to avoid, or it actually becomes appetizing to reach that issue.
So I just have one point, and then I think we should just tackle the fair use question. And Travis, you can give us the sort of background on fair use, I think. The one thing I wanted to observe, and just, Abe and Travis, if you have comments on this, let me know, is that it comes out that the Google model is something like, at least with respect to Android, it's like, we want everybody to, buy Androids. Like, we want people to program on Androids so that people will buy Androids. And we sell some Android phones, but we're not the sole seller of Android phones. And the whole reason we want everybody working with Android is because at some point, people get ads and we make ad revenue.
Right.
Now, I don't know if that's my understanding of that, but is that, because that, like you say, Abe, is a very different model from Oracle's model, which is selling licenses to software. And maybe that's kind of an old model, but that's the one they're hanging on to. Is that a kind of accurate characterization of perhaps at least two of the different models at work? And I think this will be relevant to one of the fair use elements, but is that right?
I think so. I mean,
okay,
I don't know what you think, Travis, but.
Yeah, I assume so. I mean, Google is, as a general matter, so heavily tied to ad revenue that it makes sense that is part of this, even in the Android context. I'm sure they have many different revenue streams related to Android, obviously. I mean, it's not just one thing. And just as a company at large, they obviously just have an indescribable number of different revenue streams just because they're so big and do so many different things. But I think that's a fair assumption. And one thing Abe said earlier that I think is really interesting and makes intuitive sense to me. I'm obviously not a software developer, but Apple and iOS is such like a closed ecosystem. Like, Apple controls everything, right? Like, even getting on the App Store I've heard on Apple is such an arduous process, and they're so strict. Android, I'm not saying it's like a total free for all, but I feel like the ethos of Android has always been much more open. And even like the literal Android phones are much more customizable than iPhones are. I mean, like, for the end user, you can do so many more things with it. At least, assuming you don't jailbreak your iPhone, then you can do a lot of stuff that you're not supposed to do. But so I think this Google's approach here kind of makes some sense to me in terms of their ethos for how Android works, because they're like, well, we want to attract programmers who already know Java. We want this all to be very open and kind of interrelated to the other stuff that's out there. So let's give them these familiar methods and calls that they can make. Whereas Apple is coming at it from a different perspective of like, this is our universe. We control everything. You know, you will learn our way of doing it, which I think is basically what Abe said earlier when he was talking about making a decision for where you're going to code.
Right.
Good.
Yeah.
So what I'll do is I'll just say one thing about the license. So Google and Oracle tried to get a license, right? They tried to arrange a license, and we don't know exactly why they weren't able to get there. Could have been money, right? At one point, the majority opinion by Breyer says that actually that Oracle was insisting on interoperability, but Google didn't want to insist on that because they didn't want to put any restrictions, and they just kind of want to let people fly with it. And the dissent, Thomas, just said they have trust issues. So I don't know if there's anything else there. That's sort of interesting. Abe, if you have any comment there, that's kind of interesting too.
That's fascinating. I mean, so you guys might know the answer to this, but I wanted to raise it, which I mentioned the open JDK before, which is like, you know, has a different license than Oracle's JDK. It's GPL, which is like one of these, if I'm not mistaken, like a viral, like copyleft type license.
Mm-hmm.
And I guess maybe this goes to the question of, did Google have to copy the code or not? Because I always wondered, like, well, why couldn't Google have just said, oh, you know, we didn't copy, or why couldn't not said, but why could they have not taken the path of, no, we're going to copy the API from the open JDK? And I think that's an interesting question. I don't know if there were licensing concerns there, like Google didn't want Android also GPL'd or something like that, right? So it might have been that Google was trying to walk sort of a fine line here, where they didn't want like an extreme GPL style license, but they also didn't want Oracle's restrictive licensing terms. But I'm just completely speculating here. The only reason I bring it up is, does it have anything to do with the whatever the criteria are for fair use, which I guess we'll get into. Like,
I think it does, and I'll kind of put a pin in that, but I think it does. Unfortunately, I don't know the answer either to Abe's question of why didn't they copy the declaring code from the open JDK. I don't know. There must have been some reason. I assume Google's so smart, like they had to have thought of that. There must have been some reason they decided we can't do it that way, but don't know.
Well, I think it's time to get into the fair use factors. So, because there's so much interesting stuff there. Travis, do you want to lead us off and just tell us what these factors are?
Yeah, so they're statutory, so they're actually in the Copyright Act. However, as the opinion does a pretty good job of laying out, they're not exclusive. And ultimately what you see both here and in a lot of fair use decisions is courts will always go through the 4 factors, and they'll kind of try to put all the analysis into those factors. But you can kind of tell that the ultimate decision, like they've kind of decided where they want to get from the get-go, and it's just based on whether it feels fair or not. So I think it's kind of a results-oriented thinking a lot of times, as a lot of things are with judicial decision making. They'll decide, does this seem fair or does this seem not fair? And then they will build an analysis of those 4 statutory factors to fit back to that conclusion. But there's a general requirement that courts are supposed to always go through the 4 factors. So the 4 factors are, the first one is the purpose and nature of the use by the defendant. And it doesn't say this word in the Copyright Act, but this factor has been made almost entirely about whether the use is what we call transformative. And I'll explain that a little bit more. Transformative is basically, it doesn't necessarily literally mean transforming like physically or literally the copyrighted work that you're using. It's more about the purpose and nature of the use, which is what the factor actually says. Are you using it in a transformative way? Are you using it for a different purpose than the original copyright owner? Are you using it in some totally different context than the original copyright owner? And let me give you an example that actually involves Google. It's not this case. Google Books. I don't know if either of you guys have ever used Google Books. there was a major Ninth Circuit copyright decision about fair use of Google Books, because what Google Books does is it takes thousands, tens of thousands, maybe hundreds of thousands of books. They scan them into a database. They make them text searchable. They run like some cool analytics on them, like how many times does a certain word or phrase appear in books over time, kind of like Google Trends for search results, but for the history of all books. And they put this all in this giant electronic database of books. Now, you can't buy a book on Google Books. You can't, in most cases, read an entire book on Google Books, though there are some exceptions to that. And there was a lawsuit about this, and a bunch of authors basically said, wait a minute, you just like took our books and like scanned them. Like, you can't do that. We own the copyright in those books. And this was actually found to be fair use. And the major part of the analysis was this belief that the use was transformative. And it wasn't because Google actually took the books and really did anything all that physically interesting with them. I mean, they did digitize them and scan them in, but the really important aspect of the transformative use here was, well, you can't just get on Google Books and read books, which is the original purpose. The original purpose of a book is you buy it and you read it, or you borrow it from your friend and you read it. Whereas on Google Books, it's all these different purposes. It's the trends over time. It's having text searchability, that type of stuff. So that's just one example, but that's what we're talking about usually when we say transformative use. It's less about a physical metamorphosis and more about, is it a different purpose? Is it fundamentally different what you're doing than the original copyright owner or the original use of the copyrighted work? So that's the first fair use factor, transformative use. You'll often see courts say it's the most important factor. That's not really settled law, and this has kind of changed over the decades. There was a point like 4 decades ago where actually the fourth factor was the most important, and then the Supreme Court shut that down and said, no, they're all equal, whatever. As a practical matter, I think, they get different weight in different cases. But so that's the first factor. The second factor is the nature of the copyrighted work. Bottom line, what this basically means is that some types of works are deemed to be more creative than others at a very high level. So give you an example, a novel is going to be deemed to be more creative as a general matter than software code. And I'm speaking with a very broad brush there, but that's kind of the general view of it, is that, okay, this type of work is more creative than that type of work. And you can make value judgments or disagreements about some of this stuff, but it's pretty well settled, at least in the courts, that certain types of works are just they require more creative output to create the work. It requires more creative output to make a painting than it does to, for example, organize a phone book. And the Supreme Court held at one point that the organization of a phone book is potentially copyrightable. Now, the names and the numbers are, of course, not copyrightable, but the manner in which they're organized could be. But even in deciding that, the Supreme Court and other courts would say that copyright protection is going to be thinner than the protection somebody gets for their painting or their sculpture or the movie they made. And the reason is it just does not take as much creativity to organize names in a phone book as it does to create a 2-hour feature-length film or whatever. So that's the second factor, is we're looking at how creative is the type of work that we started with. The third factor is how much of the work was appropriated by the defendant. This one is really interesting in this case because there's different ways to look at this.
Yeah.
Oracle wanted to look at it as, well, for these 37 API packages from Java, you copied all of the declaring code, 100%. So they're saying 100% of the work. Google says, well, but when you look at the whole Java API, it was like this tiny, tiny, tiny fraction of the whole thing. I don't really know which one of those is right. It's probably neither of those, and it's something in the middle somewhere. But this factor, I think, is easier to apply with other types of works than software code. So like when somebody copies a photograph, if they only copy like one little corner of it, that's very different than if they copy the entire thing, obviously. I think it's easier to understand and appreciate in that context. So the final factor is, the final fair use factor is the effect on the market or the harm on the market. And this one is often deemed to be really important along with the first one. And what we're basically asking here is, did what the defendant did with the copyrighted work, does it harm the plaintiff, the copyright owner's ability to market the work, to license it? For example, Abe talked about software licensing. That's a really squarely applicable thing here. That can apply to other copyrighted works too. If I'm a photographer and I have wonderful photographs I take of downtown Austin or whatever, I might license those online. If somebody just takes them off Google Images and starts distributing them, that has obviously hurt my ability to license them because somebody could just get them for free that way. So that's the basic analysis of the fourth factor. How much is what you're doing going to hurt the copyright owner's ability to leverage and make money off of their copyrighted work? And there are some interesting questions on that factor that this opinion raised. I think we should come back to those in probably just a second, Guha. But I'm not entirely sure that the way the majority opinion analyzed the market harm factor is totally right. I think part of it is right, part of it might be wrong, but let me pause there and let's see where we want to take this.
Yeah, so I think what we should do is kind of walk through each of the factors. And so, I mean, the majority finds that all of the factors favor Google, right? And, you know, they didn't need to do that, but they did find all of the factors favor Google. And I think we should just go through and kind of interrogate the arguments. You know, I mean, we could, again, spend 30 minutes on each one. We don't want to do that though. So, you know, we'll just walk through and kind of hit the high points and see any complaints here. And then I think what we can do is talk about just some of the thoughts in Thomas's opinion, which I think is very good. And, you know, it raises some real interesting concerns. And then we'll wrap.
Cool.
But yeah, so why don't we start with that first factor then? And yeah, Travis, like if you had any thoughts about that one.
Sure. And let me point out, just so there's no confusion, in the opinion, the majority actually discusses the second factor first, and they actually kind of flag that. They say they're doing it for exposition reasons because it makes more sense just to the narrative of their opinion or whatever. But let's start with the actual first factor, like the one that's listed first in the statute, which is the nature and purpose of the use by the defendant. This one to me is actually the trickiest one of the four in this case, because I think it's very hard for anybody who's not a software developer, and I'm not, to really grasp and comprehend how transformative is it to take declaring code from an API and put it into your Android operating system along with a bunch of other implementing code that you wrote. You know, it's a really hard question to answer, and I think the people best positioned to answer it maybe, unfortunately, are the people who are not lawyers and aren't, you know, dabbling in fair use law all the time. It's the people who actually write software and understand what it means to, you know, interface with declaring code and call a method in Java or whatever. Breyer and the majority thought that this was largely transformative for various reasons. One thing that they mentioned is it's obviously a commercial use, right? Google makes money off of Android. And the commerciality or non-commerciality of the use is supposed to come into play on this fair use factor. But what often happens, and I think there was even a comment about this in the majority opinion by Breyer, what often happens is if you are a nonprofit, you get a really, really nice thumb on the scale on this first fair use factor, because you can say, my use is not even commercial. You know, I'm an academic or whatever. Mm-hmm. But then on the flip side, if you're Google, if you're clearly a commercial entity, you can say, well, even though I'm doing this for profit, it's transformative for all these other reasons. So it's this kind of funny thing where the nature and purpose of the use can work to your advantage as a nonprofit, but doesn't necessarily work to your disadvantage as a for-profit corporation.
Yeah, and I want to just say one point here, and then we should take your advice, Travis, and ask Abe, like, what do you think? Is this transformative? But one thing I think there's a scope issue, and you have to ask, what's the thing you're asking, whether it's transformed or not, right? Yeah. Whether it's being used in a transformative way or not. Right. And it seems to me, if you look at the declaring code, right, specifically, and you say, well, you used this in this particular way, Google, was that used in a transformative way? My sense is no, because you're just using it exactly the same, for the same purpose, like the same way that you would use it in the, otherwise, like you're doing the very same thing with it. But if you ask a little bit broader and you say, well, what are you doing with this declaring code as a part of your large package, right? As a part of the whole thing. Then Google's transformative company. So it's of course doing lots of transformative things. It's doing things that are awesome, right? It's using it in a different a monetary model, as I was kind of seeding early on. So you might think, oh, so they're not doing a license thing, they're doing an ad revenue thing, and they're going to open it up to everybody. And that seems transformative, just using the sort of, you know, rudimentary common understanding of that term. That's very different. And so I think there's a scope question here that I don't think is fully explored by the opinion. It's like, what is the thing that's supposed to be transformed? I use it in that way. But so that's just one thing I noticed.
No, I think you're right on, because like what's weird about what Google did that was transformative was that it allowed you to write the same old code that you would write otherwise, and somehow get it to run on Android, right? Like, I mean, that's I can't. So I want to just impress upon people how like how non-trivial it is. If I'm writing an application, and then you said, well, you can get this app, you can cross compile this application, for instance, and have it run on Windows or Linux or Mac or whatever. Like that's a rare thing, and software developers love that. So like I think that's huge for the industry. But it's also odd because, you know, it has this feeling of, well, you're not actually doing anything different in a way. You're sort of allowing the same things to be done on this new in this new environment.
It's like the opposite of transformative for the programmer, right? It's like, right, great, I can use the same stuff.
Yes, exactly. But obviously, you know, like actually developing Android and building out Android is a hugely complex task, right? I mean, it's hugely complex.
So this reminds me, I was kind of going to make this point at the end, but I think it's actually most relevant here. So let's briefly discuss it. One of the things that every copyright lawyer knows about fair use is it's impossible to predict. Like Nimmer and other scholars have actually like said this in literal ways. They've been like, fair use is like a total mess. Like, who even knows what's fair use or not? One guy, I don't think it was Nimmer, I think it was some other copyright scholar, called the fair use doctrine a billowing white goo. That's like his famous quote. Like, what does it even mean? You know, whatever. I have found, and this is just a personal opinion, it's very anecdotal based on over the years of reading a lot of fair use decisions. I have found that the easiest way to predict whether something is going to be found to be fair use or not, and I think it speaks primarily to this transformative part of factor one, is how much does it promote useful technological progress that benefits all society.
Yeah.
And because of that, the economy and people's lives, et cetera, et cetera. And this also goes back to my point from earlier of, it's not the four factors driving the conclusion. It's really the conclusion driving the four factors, right? So what happens here is, in this case, 8 judges considering it, and 6 of the 6 justices say, it seems fair that Google should be able to take this pretty basic declaring code and build something so incredibly powerful and awesome with it. The Android operating system, which now is in the hands of so many people's smartphones across the world. And from there, you kind of build your analysis of why it's transformative. Well, it's because of what I just said. It's transformative because it kind of helped change the world in terms of putting such a powerful device, a powerful operating system into so many people's pockets. I think it's not in the statute. It's not, you know, in a lot of cases, it's not even directly referenced in decisions, although it is a little bit in this particular decision, at least tangentially. But I think looking at fair use and transformative use through the lens of technological progress and benefiting big chunks of society with whatever it is that you're making is probably the most useful and predictive way to think about it.
Great. Yeah. So, and then let's go to the first factor right there, because it's also, you know, it's pretty close. So we can talk about that one, and then we'll round out with the next two.
Yeah. So yeah, the factor that they discuss first in the opinion, which is actually the second factor, right? The nature of the copyrighted work. So to me, you know, this one you have to put in context of, I think, not just software code, but like I was talking about before, all the types of copyrighted works that are out there. And I don't want to say anything that would be considered like slanderous to a software developer or like the people who wrote the Java API. But I think it's pretty intuitive to a lot of lawyers and a lot of judges that software code, particularly declaring code that is just defining, the name of the method and what the parameters are, is just not as at its core creative as some of the stuff we talked about before, a novel or a photograph or a painting or a sculpture or whatever, all these other things that copyright protects. So I think you have to look at it in the concept, in the context of not just software as a beast of copyright, but all the various things that can be copyrighted. And on that spectrum, I think it's probably fair to say, at least in my opinion, that declaring code falls on the less creative side. I'm not saying it doesn't take any creativity at all, but I think that's a fair conclusion. And I agree with that part of this opinion. And I think that probably, in addition to the exposition thing that they said, I think one of the reasons they probably wanted to discuss that factor first is it makes a lot of sense to look at it that way. Say, we're just talking about some declaring code, like this is not, Lawrence of Arabia or something, right?
Yeah, I'm going to push back on that. And I want to hear what Abe has to say, but I'm going to give a very brief pushback on this, because it occurs to me that like the coding is tough, right? And it's one of these things. I was a mathematician and I just avoided it at all costs. It's just like, I think it's tough. So the more intuitive you can make it and the kind of structure that you can give this so that you can felicitate people, like coding well and quickly and intuitively, when I talk to Abe and I talk to other programmers, it's something that really speaks to them, right? It excites them. It's like, and I think that there's real creative, intellectual heft going into that, creating those structures. So it occurs to me, it's very different, but it's also really important and creative in that way if you can do it intuitively. So that kind of I understand is different from the other kinds of works, but I just think in terms of IP being, do we want to validate and encourage this? I think so. So I want to hear what Abe has to say on this, because I'm sure he has lots of thoughts.
Yeah, no, I mean, I take your point, Travis, about situating it in the context of other non-programming artifacts. What I find interesting about this whole declaring code versus implementing code aspect is that, so I've been programming for 4.5 years. I can hook things up all sorts of different ways, okay? But I'm not nearly as good at defining, at creating a well-defined API, okay?
Mm-hmm.
Well-defined APIs are hard to come by.
Yeah.
And you can look at, software projects from decades past, and you can see examples of great APIs and examples of just awful APIs. And that's because, creating a good API is actually just a really difficult thing. So even though I don't think it takes as much, as many man hours in the end, right? If you say the actual implementation of Android was, took huge effort for sure. But I suspect that they decided to use the Java API precisely because it's a good API, right? And so I don't know if that links to creativity. I guess I wanted to ask, is there a link between the amount of time that it takes to build something and how creative that task is, in your estimation?
I would argue that if I were arguing for copyright protection of something like this, that would absolutely be part of my evidence. I would say, if this doesn't take creativity, why did it take us hiring some of the most talented software engineers in the world to think about this for literally years of their lives and come up with all this stuff? And I think there's probably some intuitive appeal to that argument. One thing that I think would create some pushback there, and this maybe came up at earlier stages in this case, it didn't really make its way to the Supreme Court for various reasons, is if I were Google, if I were on the opposite side, I would say, wait a minute. There is a whole separate area of IP law, patent law, that protects when you make something useful, and it's not obvious, and it's useful, and it is novel. And if you create something that it rises to that level, you can patent it, and you get 20 years of patent protection, and then it goes into the public domain for everybody. But what you can't do is say everything is creative just because you spend a lot of time working on it and then get copyright protection. Right. And it's a really important distinction for lots of reasons, but one of them is just the term of the protection. Right. Patent is 20 years from issuance. There's some exceptions to that. Copyright protection is the life of the author plus 70 years on top of that. And in this case, the author might have been multiple people, but it's literally referring to the life of the original programmers, presumably at Sun Microsystems, who wrote this stuff. And probably most of them or all of them are still alive. I don't know who's actually listed as the author on the copyright application, but it has to be a person. And so as long as that person is alive and then add 70 years on top of that, that's how long this would be copyrightable and somebody could exclude. And so if I'm arguing against that, I say, well, what it sounds like, Your Honor, is they wanted a patent. They couldn't get one because it didn't meet the requirements for patent. So now they're saying, give us copyright that's going to last for 70 years after all these developers are dead, you know? I'm not saying that's necessarily right, but that would be the counter argument there, I think.
That's a great point. So now I think we should talk about the amount and substantiality of the portion used, right? And I want to start this off, and I just want to let you go with it, but I found this statistic here to be somewhat meaningless, right? Like, it seems like Google could reduce the meaning of this, like it could, by writing more dummy code, right? Like, it could just add code and say, it's a smaller and smaller percentage. And, you know, I mean, one of my students, DI, who worked for Google and is at Harvard Law School, was telling me that yeah, he just didn't really think this was very meaningful statistic, and that actually, like, well, you know, a lot of the code itself is, you know, just kind of like sort of parted in, and, you know, and it's like very standardized. So it's not really like, oh, the rest of this was creative in the same way. So yeah, but Abe, what can you tell us about that?
No, I mean, I think it's the same. Your comment about it being a scope issue applies here too, right? This is it. You could say if it's the declaring code, excuse me, that's at issue here. Well, you copied the whole thing, and that was sort of the point too, right? Like, if you hadn't copied the whole thing or effectively the whole thing, then it wouldn't have given you the benefit that that you wanted, which was that all the facilities that are available to someone writing an application in Java are available for them writing an application for your Android platform. So I think this is a hard one for sure.
Yeah, let's maybe put it into an analogy for a different type of copyrighted work and see if that helps us think about it. So let's say there's a book, you know, a novel, and obviously a novel consists of sentences and words. Let's say I write a competing book, and in my competing book, it's the same genre. It directly competes with that first book. I copy some individual sentences here and there from that first book. I don't copy the overall plot. I don't copy the title or whatever. But every now and then, like in every chapter, there's some sentences that show up. It's like, wait a minute, that's the exact same wording of that sentence from the first book that you're competing with. Would that be deemed to be a fair use if the author of the first book says, wait a minute, you copied little pieces of my book? And where it would come down on this factor, I'm pretty sure that at least part of the analysis would be copying a few sentences out of your book, even though they were copied verbatim, is not copying enough of that book that we're really, really getting to a point where they have infringed your copyright, which is not in individual sentences, of course, but which is in the whole book. And I think if you look at that in the context of the Java API, probably part of what Google's saying is, we have no doubt that the Java API as a whole took a lot of work. Maybe it's copyrightable, maybe it's not. But even if you assume that it is copyrightable as a whole, we took so little of that API that it's kind of like taking 5 sentences from a novel and putting them into your book. And in my example, of course, it's a competing book. I think Google would also argue we're not directly competitive with Oracle on this anyway. So I think that's a potentially a helpful way to look at this analysis. I do think it's more important, much more important, how much of the API Google took versus how much of Google's Android code consists of the copied code, if that makes sense.
That seems totally right.
You can't just write dummy code in Android or add a bunch of fluff and then be like, look, the copy part is only part of it. What we're asking is, how much of the plaintiff's work did you take, not how much of your work consists of the infringing material.
I think that's such an important point, right? It's got to be the thing being copied that you're
Yes.
considering, right?
Yes.
That I think is a really important point.
And to
And I
take it
will
back
say-
to my book, analogy, if I take the entire book and make that the first 20 chapters of my book, and then write 5 more chapters on the end, I have undoubtedly infringed somebody's copyright at that point.
Exactly. I think that's totally right. That's what I think, the Oracle folks are going to say is like, well, you just took a chapter of my book. I have a 3-chapter book. You took the full first chapter and you just dumped it in, right? And then you added 25 more. Okay, well, that doesn't help me. But yeah, no, I think that's, so, I mean, I actually think that the question of the substantiality is an open question. The amount and substantiality question is an open question. But I just found this particular appeal by Breyer to be not so significant as you suggested. Well, so now I think we should just talk about the market one. And I think it's really interesting, and there's a scope issue here too. But let's talk about the market factor.
Yeah, this one's really tricky because it implicates some of the issues Abe raised earlier of how do these respective companies make money? What are their various models? Obviously, for Oracle, a lot of it is licensing revenue. Google is, I think, in general, much more complicated of a company in terms of the different ways they make money. That's not to say Oracle is not a huge, complicated company in and of itself, but the market harm often in copyright often has to do with loss of licensing or royalty revenue. It's not always that, but it's often, that's a helpful way to look at it. I mentioned that earlier with my example about the photograph, right? If I'm a photographer and all of a sudden somebody's taking all my stuff and putting them on various websites or whatever, where people can just download them for free, well, you've certainly harmed my ability to collect the licensing fee. I think it's fair to say that what Google did here harmed Oracle's ability to collect a licensing fee, because absolutely Google could have paid Oracle to license everything, including the declaring code. To me, there's absolutely no question there. What's interesting is that clearly did not carry the day on this factor, right? And sometimes it does. In simpler cases, maybe ones that don't involve software code, things like photographs or other more creative works like I was talking about before, I think that very simple analysis often tips this factor in the plaintiff's favor, in the copyright owner's favor. But here, and I would have to go back and reread this section to remind myself how much Breyer directly grappled with it, but it seems clear to me that this harmed the licensing / royalty market for Oracle of the Java API. And yet, this factor did not tip their way. And obviously, the overall fair use analysis did not tip their way either.
So I want to say something about this here, because Breyer's analysis of this is pretty interesting, because initially it goes on about how this is not that creative, right? There's not much of a market for this thing, right? And it kind of goes on and on about that, right? And so it suggests there's not really much of a market. They kind of failed out on the market, right? Oracle didn't do very well with this, et cetera, et cetera. And then at the very end, it says, finally, given the way programmers operate, this would be extremely disruptive to the market.
Right.
And that seems like a heads I win, tails you lose situation, okay? Yeah. It seems it's sort of like there's not much of a market for this. And by the way, if you really insisted on this, you could disrupt the whole market. Well, that sounds like there's a market for it, right? If I could disrupt the whole thing by insisting on, my licensing fees, it sounds like there's a huge market for it.
Well, let me comment on that very briefly, because this part of his analysis, I think, is wrong. And maybe there's some case law or secondary authority he drew on to help him get here. But if you look at the Fair Use Statute, the Copyright Act, 17 U.S.C. 107, and you look at this factor number 4, what it says, the effect of the use upon the potential market for or value of the copyrighted work. Let's focus on that last part. We're talking about the value or market for the copyrighted work. To say, wait, if we didn't let Google do this, it would hurt the value of this other stuff, whatever. I'm not sure. That's not what the statute says. The copyrighted work, at least arguably, we're assuming that the Java API is copyrightable, right? That was the predicate assumption. So the copyrighted work, those last 3 words of this statute, is the Java API. So really the only thing we should be asking under this factor is, how did Google's actions affect the value of the market for the Java API? Going into this other stuff about how it would harm programmers' ability to do X, Y, Z or whatever, I don't think that's what this factor is asking about. That may be relevant to fair use. It probably goes under transformative use and maybe even touches on the other factors. But I think this second half or this last part of his analysis of factor 4 is statutorily incorrect. I think it's irrelevant, frankly. And if I had been writing this opinion, I think I'm not really sure where I come down on whether this is fair use. But if you assume that I was told by the majority justices, hey, you have to write an opinion that says this is fair use, I would have tried to write one that said factors 1, 2, and 3 favored Google and factor 4 favored Oracle.
Right.
That's what I would have done. I would have
Right.
said, yeah, this clearly harms the market value for Oracle's Java APIs, but the other 3 factors outweigh that, especially the transformativeness of the use. My personal opinion.
I agree with that too. Abe, why don't you tell us what you think about the sort of market effects from the sort of
I think they're massive, and I agree with everything that Travis has said. I mean, I actually want to ask you guys this question, which is, can you conceive of a case in the future where it's not deemed fair use, but it is, like, what would be an example of an API what would be an example, do you think, where the court would say, yeah, it's not fair use? What would Google have had to do differently here? What would have had to?
Well, it is such a great question, and I think it leads us to the dissent. And so, I think we can tie it together, because I think Travis disagrees with me with this. The Thomas dissent points out that the majority has sidestepped the very important question of whether this thing is copyrightable, right? And it's just sort of, we assume that it's copyrightable, but Thomas says, well, that's where all the action is, and the majority improperly sidestepped this. And what I will add to this is 2 things. I will say that in the course of discussing fair use, the fair use factors, I'm not saying it was, I just think the majority said a lot more about the copyrightability of this thing, right? I think they were saying this is very low value, maybe not even copyrightable. And the second point is, in deciding the fair use of this thing, the fair use question, I think they said, as you point out, Abe, right? I don't know how an API that's copyrighted can ever generate, can be infringed such that it generates damages. Like, I don't know how that's possible.
And just to add on a little bit to that question, like, this API in question is a fairly massive API, right? Like, when you think of other products that expose an API, the surface area of that API is fairly minimal. Here we are talking about, a lot of functionality in this declaring code. So yeah, I don't know.
Yeah, these are really tough questions. If I had to come up with a kind of extreme case that I think would be a tough sell on fair use, it would be another company that sort of specializes in providing programming languages, APIs, things like that, copied not just declaring code, but copied an entire API, copied all of the implementing code, copied all of that stuff, and put a new brand name on it. And then we're like, hey, check out our new API. I mean, that would be a very, very tough sell on fair use, honestly, right?
Yeah, but that case might not have anything to do with the declaring code at all. They could just point to the implementing code and say, look,
that's
you just
right.
So
the question of, is copying declaring code ever not fair use, right? It's a tough question. I don't know.
And look, if you decide that it's always fair use, have you not just decided the copyrightability question for all practical purposes? I mean, I understand there's a formal distinction. Am I missing something? Is there something that?
That is a really, really interesting question. So, I mean, the answer is you sort of have, right? Because to own a copyright is to own a basket of exclusive rights, which is like it's the bundle of sticks, right?
Yes.
It's a little bit different than the traditional bundle of sticks, because the Copyright Act actually tells you these are the exclusive rights you get for owning a copyright. But if you can't sue somebody to enforce your exclusive rights, or if you're always going to lose because it's fair use, you kind of don't really have exclusive rights, So I
That's
think
what I would think. Yeah.
that's a fair way to look at it. I wonder though whether, going back to my point from earlier, I think that there are other companies besides Google, other enterprises that would, for various reasons, have a tougher time establishing fair use. And it's not simply because they can't afford the best lawyers in the world like Google can, although that certainly plays into this type of thing. But because Google is, everybody knows Google's on the forefront of innovation. It goes back to this point from earlier. They come into every case about this type of thing, I think, with a little bit of a tacit presumption that maybe what they were doing was more transformative than the average company because they are Google, right? They're known for disruption and innovation and all that stuff. So I would not assume that nobody could ever get popped for this type of thing and nobody could ever get hit with a finding that's not fair use. Keep in mind, the Federal Circuit, 3 judges said this is not fair use. Sure. Now the Supreme Court overruled them, right? But they got 3 people to say this. I believe it was a unanimous, all 3. It may have been a 2-1. I'm actually forgetting. But either way, they got a majority of the Federal Circuit panel to say this was not fair use. So reasonable minds can disagree on this, but I think lesser companies than Google, not in terms of size, but in terms of the perceived impact they have on technological development, might have a harder time coming in on this type of thing.
So we have talked for a long time on this stuff. So I'm going to do a last round of things that you guys noticed in the opinion or, questions for the future, and then we'll close out.
Hey, if you want to go first, you want me to go first?
No, I mean, yeah, why don't you go first? Yeah.
Well, I think that there are parts of this opinion I don't agree with. I identified the most important one, which is that last half of the factor 4 analysis. I think it's wrong. And to sort of point people to the part that really sticks out to me, it's where Breyer writes, given programmers' investment in learning about the Sun Java API, to allow enforcement of Oracle's copyright here would risk harm to the public. That is not what that 4th fair use factor says. It's just not. Now, I don't disagree that idea plays into what's fair. And like we talked about before, ultimately fair use is a holistic, equitable doctrine. These are not 4 exclusive factors. But for him to throw that in there like that, I think, potentially distorts things a little bit, especially for future cases that will rely on this opinion. This does not, in my opinion, belong in the 4th factor. It's just the wrong thing. The only other thing I wanted to say that we haven't talked about at all, and this unfortunately is not of interest to software developers at all, it's only going to be of interest to lawyers. This opinion from the Supreme Court does something really, really important that has nothing to do with the substance of fair use law. The Supreme Court says in this opinion that fair use is an issue of law to be decided by courts, not to be decided by juries. The underlying factual questions can still be decided by juries, but this is our first Supreme Court law, clear on-point law on the proposition that when you litigate a fair use issue, an appellate court now basically has carte blanche to say something is or is not fair use, regardless of what the jury said on that question. That is a pretty huge sea change. Courts were doing that sometimes already, as the Federal Circuit did in this case. But for lawyers who litigate these issues now, you can no longer just rely on the fact that let's just get the jury on our side and the jury will get deference to their verdict. Because the Supreme Court just told us, no, they won't, right? If there's some predicate factual question that somehow is overwhelmingly persuasive, like for example, whether it harms the market, a jury can decide that fact or not, then maybe you'll still get some sort of de facto deference to the jury verdict. But you're not going to get any true deference to the verdict on the fair use question anymore after this. And that's a huge thing for people who actually litigate these cases. Because you're not just litigating them once, right? Yeah, go to trial, I won. Well, that was just like litigation round 1, and I'm starting over from scratch. I convinced 12 people or 6 people, however big your civil jury is in a particular court. I convinced all those people this was fair use, but now I got to convince 3 more on a circuit court that it's fair use. And then I go up to the Supreme Court, I got to convince 9 more people it's fair. Like, how many people do I have to convince this is fair use or not,
Such a great point.
Yeah. Yeah, I mean, I what I find really interesting in conversing with you guys is my feeling is that this was an equitable outcome here, like this is a fair outcome. But then as we've gone through the actual factors of fair use, um, that's been sort of challenged. I mean, to be quite honest, I feel like you can make as good or better arguments in Oracle's that go in Oracle's favor for each of the factors. So, and I very much am left with this question of, well, hey, they've sort of ducked the what I concede to be the main issue here, and we still don't have a real answer to it. And I don't know. I can't tell whether we're going to get an answer to that in the future, or if we'll always be in limbo here. So I was generally confused by this opinion. I don't think it changes the status quo that much. I think it's sort of a reaffirmation of, hey, whatever the industry was doing before, we're not going to change things that much.
Yeah.
And I do think that if they had decided that first issue one way or another, there would have been big changes for someone. So yeah.
I'll just say that a couple of things that we didn't talk about fully, but I do think that this thing that still just sort of rankles me is this notion of creativity here. I just think like, well, actually there's quite a bit of creativity if you try and do that stuff, and maybe lawyers are less inclined to think some things are kind of creative and others. So that one, it still sticks with me. The other point that I'll make is that Breyer early on keeps saying something that we didn't explore, but he keeps saying that computer programs are all functional, and it's like unlike other stuff, and that use of functional there is not defined, right? I don't know exactly what it means. I have a sense of what it means, but I don't know exactly what it means, and I think it's a little bit of a kind of it sort of lurks over all of this area. Now, part of me thinks that it sounds in the thing that Travis brought up earlier, which is that you're really talking about something that's patent, and you're trying to smuggle it into, copyright, but it's got this functional nature to it, and it should be evaluated on these patent sort of things. And we're going to give a less deference to it. But, I think music is functional in certain ways. It makes me do things, right? It makes me happy. It makes me. So that notion of functional, I think, is just. I'm not saying there's nothing to it. Intuitively, it makes sense. I just think it's a little mysterious.
Yeah, but I think that there's a lot to it, right? And that's the biggest reason why sort of treating it like a book or something is such a bad idea. Look, when we're talking about, I think what he might mean by functional here is that the operation of any sort of like complex system relies like on multiple components, and you actually just can't build a system of any complexity unless there are like these well-defined interface points between the components, and that requires stability. Like the big thing with APIs is like that they are stable, right? That this is how component A is going to interface with component B, and there's some stability to that. And then I can build on top of that. And if you don't have these stable, common sort of interface points, well, you're just, it's going to be a free for all, and nobody's going to end up. It's going to be bad for technology. Let's put it that way. So yeah.
I'm sorry to interrupt you, Abe. I just think
no.
it's such a fascinating point about functional. There are some other areas of law where we have doctrines of functionality that actually mean something. That's not what Breyer was referring to. He just kind of threw the word out there in a colloquial sort of a way. The best because you had raised this, Guha, before, and when I was reading some of your notes on the opinion, and when I thought about it, I struggled to come up with a clear answer of what he meant by that. My best guess is he is actually tapping into a couple of things. First of all, the point you mentioned about patent law, even though he doesn't say that, right? But we do have this whole area of law that is meant specifically to protect useful, novel, non-obvious inventions that advance the technology in some way or another. And so he may be tapping into that a little bit. And the other thing that he may be tapping into is just this idea more holistically that I mentioned before of technological progress. Because, movies or music have gotten different over time, depending on your taste. Maybe they've gotten better over time, but they don't really build on each other in the same way technology does necessarily. Like, things change, whatever, but technology has this sort of recursive way of feeding back into itself and building on itself and becoming bigger and bigger over time.
Right.
And that's in some ways exactly what an API is helped to make is meant to do, right? It's to allow programmers to build bigger and better things using the API. So I kind of suspect that's maybe part of what he meant by functional, but it's a guess. I don't know.
Yeah.
Yeah. Well, we're left guessing, and I think, you know, one interesting topic I'd love to see is an opinion or an article or a blog post telling us a little bit more about functional, you know. But as you guys point out, there's a ton of questions left, and but yeah, this was great, and yeah.
Yeah, I enjoyed it, guys. Abe, thanks so much for your input on the technical side. It was really, really fascinating.
Awesome.